supply chain management policy
Yes.
that is folded. What we are depositing before the OSPC kindly see. Landing cost, that is cost of the liquor, that is cost of the liquor, landing cost. Then additional landing of exercise, that's not, then applicable state excise duty, the duty which we have paid to the state, applicable state excise duty, countervailing duty, vending fee, additional rounding of excise duty, then that becomes the purchase price. C plus D, that becomes the purchase price. Thereafter, profit margin 1% we deposit, then issue price A plus G, thereafter 35% VAT, then 1% TCS. All these we deposit, whatever amount we deposited in the OSPC wallet, they deduct in these headings, meaning thereby duty is included in the money we deposited before the OSPC. OSPC deducts takes deposit of duty and remits that money to the state government. But here what has happened, on account of earlier interim order which has been upheld by your lordships, we have deposited the duty to the duty only before the government. Now we are supposed to pay rest of the amount to the OSPC, but what the OSPC is doing is ask
That is excise duty you deposited with the government.
Rest of the money we definitely pay to the OSPC. But OSPC is one way, deducts duty amount as well. So there has to be a connection between OSPC and the government. Now the London Secretary passes an order, kindly see after your lordship passes the order. Though he has said that we have to deposit the cost of the liquor. That was admitted. We have to deposit the cost of the liquor. Last but one line, the paragraph, kindly see. The licensee is hereby allowed lift liquor on payment of corresponding sum with OSPC wallet till the validity of license lasts. So OSPC wallet, the duty is there. OSPC is not accepting any amount without duty, which I would have paid already to the state government. So in my humble opinion, what the London Secretary should have done is, that should have passed.
There are two aspects. One is that he should have deducted that particular amount of duty already deposited.
Yes.
If the system does not really permit so,
Right, my lord.
if there is then whatever the amount which you have deposited should be refunded to you.
Exactly to the OSPC.
That is the only solution.
That's the issue.
That's the only solution.
But it's a confusion altogether.
Whatever. So let us hear if that's the only solution. If the excise duty has already been paid.
Case is not about excise duty at all. Purchase duty. Duty on purchase, no, Miller. It is about penal duty, Miller. My lords, let me give a background. My lord knows that a license is for 1 year. A license period is for 1 year. And when every license is issued, my lord, an MGQ is mentioned. That MGQ is mandatory. Now, my lords may kindly have the statute. My lords may kindly have Rule 34 and 35. My lords may kindly give me 2 minutes. That's 2 minutes. My lords may kindly have Rule 34. Rule 34, my lord, speaks about payment of fee in consideration of grant of exclusive privilege.
Yes.
My lords may straight away come to the explanation to this rule. That explanation speaks about MGQ. For the purpose of this part, the expression minimum guaranteed quantity means, my lord knows that. Now, my lords will see sub-rule 6. The quantity fixed as MGQ shall be counted at the end of the year to ascertain the shortfall of the MGQ of that year. 7. The licensee shall lift the entire MGQ of country spirit, IMFL and beer for the entire year or portion thereof as fixed by the state government before the expiry of the term of the license, that is the last day of March. Because not 1 year is the financial year. Now, my lords will see sub-rule 8. In case of default, if this MGQ is not lifted, the excise duty on the deficient quantity of the annual MGQ without prejudice to any other mode of recovery shall be collected at the end of the year with a fine or the rate of 10% on the deficient amount, and on failure to such fine, the same shall be recovered as areas of land revenue. Now, my lords will see Rule 35. Rule 35, to whom licenses or exclusive privilege for sale of intoxicants not to be granted. License or exclusive privilege for the retail sale of intoxicants shall not ordinarily be granted to a person who has been convicted, B, to a former licensee who is in area to the state government. Now, my lord, the petitioner defaulted in lifting of the MGQ. My lord may give me 2 minutes. So, my lord, may give me 2 minutes. Because there was a default. Because there was a default, my lords. Because there was a default, a demand notice was issued that my lords will find at page 25. Page 25 of the writ petition. This is dated 25, 2024. Yeah, my lords, it says, with reference to the letter on the subject cited above, it is intimated that the show cause reply submitted is not sufficient. Next paragraph, it is found that you have defaulted to lift for 176,750 LPL of IMFL during the year 2023-24 against the MGQ. As per Rule 34.7, which I have already placed before my lords, the Odisha Exchange rules, you were bound to lift the entire MGQ, for which the license had been granted. The next page, my lords. Next page, first paragraph. Next page, first paragraph. In the meantime, the government, by so-and-so letter rating, has been pleased to allow the defaulting licenses who have not renewed their shops for the year 2024-25 due to shortfall of MGQ for the year 23-24 to renew their shops by defaulting the duty amount and shortfall of MGQ on installment basis. That is 50% of the amount as first installment by 25 May 2024, 30% by 15 June 2024 and July 2024. Challenging this, my lords, the petitioners approach this honorable court. Now, this honorable court, my lords, will kindly see page 18, my lords. Page 18. As an interim measure, my lords, this honorable court, this is on 11/9/2024. This is basing on this order, my lord has passed the earlier order that my lord senior was placing my lord's order. Mr. Rath, learned advocate appears and so submits demand notice dated 20 May 2024 and challenge this short lifting of MGQ. I've already paid the demand notice. Last paragraph, my lords. He submits that there should be direction for his client to deposit 50% on or before 19th September. So they create for a little breathing space. Now, my lords have directed that paragraph 4, petitioner will deposit 50% of the demand by 19th September. Instead of May, they say 19th September, my lord said. In the event of deposit, she will be allowed to lift corresponding quantity on a license, which is appropriately renewed. Because my lord, license will not be renewed if MGQ is not lifted. So license will be renewed and they will be allowed to lift MGQ as per the renewed license. This is what was directed by my lords. My lords, we allowed them, we renewed the licenses. That my lords will find at page 50, my lords. No, sorry, my lords. 30. Page 30, my lords. Page 30. The license was renewed, my lord, and at the top of the page, monthly MGQ was fixed. Another MGQ was fixed. So they were given some breathing space to pay 50% of the demand amount, and then the licenses were to be renewed, and they were allowed to lift the MGQ against the renewed license. Now they're claiming that against that deposited 50%, they will lift MGQ again. How is that possible, Mullahs? Well, that is not the purport of the order, Mullahs.
Very interesting.
Yes, Mullahs, because that is a pending consequence.
Then what is the purpose of this? What is the purpose of passing an interim order directing them to pay 50% of the deducted amount? It's a merely a fund which the court.
They have deposited 50%.
Then why the court says that they will be entitled to lift the MGQs, appropriately renewed the license? That shows that not only they have to make good the shortfall of the previous year, but also they have to maintain the MGQ of the renewed period as well. So this is how the mechanism that has been adopted. You did not challenge that order.
No.
You did not go that. What is the purpose of writing this sentence?
Yes, Mullahs.
In the interim order?
Yes, Mullahs.
I just fathom to assimilate. Please read the order. I am not making any comments, but read the order. What is the paragraph 4?
Yes,
the petitioner will deposit 50% of the demand by 19. In the event of deposit, she will be allowed to lift corresponding quantity on a license.
The license will not on the 50% demand deposited. License is
very interesting interpretation.
Yes, Mullahs, that is my interpretation.
That's true. That the court's interpretation you understood.
Event of deposit
was passed when actually and in fact the license was not renewed.
That is why
if the order is passed before the renewal, what they say is that unless the license is renewed, they will not be permitted to lift, because nobody can lift the liquor without a valid license in his favor.
Yes,
so that is why I say the 50%. Then can't you imagine what would be the consequences? It is really
Milord, there is no lifting against the MG. Milord, this is a penal consequence, Milord, of not lifting the MGQ. How can they again introduce the MGQ, Milord?
Look at their own demand.
No, Milord.
That
Milord,
demanding is just
let me clarify, Milord. MGQ, if it is not lifted, Milord,
Where is the officer?
Milord,
Where is the officer? Let me hear him, what he understood from this
Very
order.
well, Milord. I will summon the officer. He will be present.
Yes, we are directing this to appear before us,
My Lord,
to appear before us tomorrow. Let him understand.
if my Lord allows me 2 minutes.
For tomorrow is a holiday.
At 2 o'clock, I tell you.
No. Why 2 o'clock? On Monday, the officer will come out 2 o'clock. 2 o'clock on Monday. My Lord, may see. My Lord, may kindly, my Lord.
Mr. Raj, first of all, you cannot interpret our orders. If
No,
you-
my Lord. My
if you
Lord,
require any clarification,
Your authority who is tinkering with the order of the court.
No, my Lord. My
It
Lord,
is,
give me.
I do not know
My lord,
what impression has been given in his mind. I do not know. But if he has perceived this, then it is a high time that we should.
My Lord will give me 2 minutes, my Lord. Let me try once again.
You have already exhausted 2.5 minutes for
MGQ
first,
My Lord,
on your first phase.
MGQ is minimum guaranteed quantity.
Sir, I understand then why these interim orders. Please consider you did not challenge this order.
No, we are not challenged. We are not
Did
challenged.
not.
My Lord,
If the court has passed an order which is still operative and binding on you, then only thing is that if you interpret in this particular manner, then in that event we have to understood the purport of the order, what order really speaks of, and if the authorities have misinterpreted the order, they have to be corrected. So
Yeah,
let
they
them
have to be corrected.
let it be corrected. I do not know how he could perceive this. What is the purpose of giving this 50%
My Lord, may understand.
deposits?
My Lord, the statute says if the MGQ is not lifted, my Lord, penal consequences are provided for in the statute. It says, my Lord, fine will be levied, license will not be renewed.
The court has not interfered with the demand which you have raised.
The court has
The court has, by way of an interim order, simply says that you have made a demand, 50% of the demand they will deposit. Immediately on a deposit, they will be permitted to lift the entire MGQs. That means the period, that is your perception, Mr. Rao.
MGQ on the renewed license.
Sorry. Then what is that's why I say you misunderstood the English language. It says that you will be lifted on her license appropriately renewed. That means that this MGQ which talks about situation, a license is renewed now, fixing an MGQ, he is entitled to lift this MGQ for the entire period of a renewed or entire renewed period.
Yes.
Can you impose any kind of a fine or penalty?
No, my Lord.
He is entitled to, and then in that event, you cannot charge even a penny from them.
You cannot.
You
But
cannot.
it does
Then
not-
what is the purpose of this deposit of 50%?
If it does
I am
not,
asking you, and why the court says lifting of the MGQ? If the intention which you have gathered that this relates to an MGQ fix on a renewed license, then 50% deposit under what law?
because my Lord, this honorable
Sorry.
has
No, sir. No, sir.
certified that the
Then,
demand is
no, then the question, he should say on that of the 50% of the demand, the authority would appropriately renew the license.
The language-
Had it been this situation,
My lord-
you would have understood.
My lord,
Yes,
the language-
because
My lord,
you
the language-
cannot renew the license unless the entire demanded amount is paid.
My Lord, the language is to lift corresponding quantity on a license appropriately renewed.
Sir, I am asking you, that is what I am saying. Please try to understand.
Court's order is to be read as a statute book.
No.
I'm
My Lord,
correct. Again, repeating, I think I have not been able to establish a wavelength of mind with you.
Your lordship will.
Again, in a very simple language I am giving. If a license is renewed, that means he is permitted to carry on the business.
yes, ma'am.
that if the license fixes an MGQ, this MGQ is fixed for the renewed period. Is it?
Yes, Mullah.
That from April of a year till the March of the next year, you will have to lift this much quantity. So the breathing space of 1 year is given to him. If he lifts the entire quantity which is earmarked or which is fixed in that renewed license, then he cannot be settled with any liability. Is it very
Yes,
clear?
yes.
Now, question is that if the court says that please pay the 50% of the demand in relation to a previous year, not the renewed year, if you deposit, then you will be able to lift. This is a condition which is put. If the license is renewed, then there cannot be any condition for lifting the MGQ because you are permitted him to lift. If he puts a condition that if you pay 50%, then and then only you will be able to lift the MGQ, then in that event, it is relatable to a previous year, not relatable to a renewed year. And then the language is that since the license must be there, so the court has said that appropriately you have to renew the license on the deposit and lifting of the MGQ by payment of 50%. This is what the intention is.
Thanks, Mr.
I'm not saying now I understand. Now I understand.
Now you understand why say you should understand.
I understand.
If not refunded in the meantime, will refund.
In a content.
That, instruction, first time it has come.
So we are directing a service. Content is no instructions.
Yeah, only I pay, if not paid, we'll pay in the meantime, sir.
You pay.
Yes.
You have to record your under.
Yes.
Kindly see page 17, my
Interest they have
Lordship order. Lordship, kindly see page
some excess amount
20.
that has been refunded and interest on the excess amount he has paid. That used to be.
Page 20, my lord, last two lines. Since the principal.
By water, this is the content application at the behest of the petitioner and the. Yes, you are not scaling even a school.
My lord have already invested. Similar matters.
I'm asking you, who are not sparing even a school. Who is a petitioner?
Also,
So what is this?
consider better.
Sishu Vidya Mandir, what more? You are not sparing and you are chasing them under the Income Tax Act. And that too is Ma Saraswati. Over and above is Sishu. And third component is Vidya. What are you doing? What? Anyhow, on a lighter moment, is what is happened? What is this?
Challenge the
Exemption.
exemption that is in violation of
For the previous period.
previous period of
Section 12A.
whatever, 12. Second provision. Already given.
What already? What?
Similar also.
Similar also.
That will be effective from the previous period. Statute.
Right. That is second provision to
Where is your exemption certificate?
Income certificate is there.
Covered. Next.
Item number 3.
The single bench assignment matter because the code number is wrongly given, so that is how it has come before our lordship. Earlier it was only single judge. Single judge directly collected disposal.
You have justified your first name.
I said before that same thing.
It is submitted by the now the thing that have wrongly been listed.
My lord, this is the demand and recovery certificate issued by the GST authority without giving me violation of the principles of natural justice. And this honorable court
Without the violation of the principle of natural justice.
no. In violation of the principles of natural justice, and several judgments passed by this honorable court. My associate is there placing the judgment of this honorable court that it has to be remanded to the appellate authority to file appeal within the petitioner. And also it is a period, time barred period, and which
Page 11. Your Lordship, the dates may kindly be looping.
27-2. This page 11 is this.
Your Lordship, page 10, the prayer started from page 10.
Correct.
Page 11, Roman 1, your Lordship.
Oh, watching
The dates 22 and 23, the writ has been filed in 2026. And the allegation is that the orders have been uploaded in the portal. The show cause notice as well as the orders have been uploaded in the portal and natural justice has not been provided. Your Lordship has categorically decided so many judgments, Your Lordship, that as per section 169 1D, the order has been notice and order has been uploaded on the portal. That is a valid service, Your Lordship. And catena of judgment, Your Lordship has already decided in 2 cases and dismissed on the ground of delay and laches, Your Lordship. And by citing that judgment of Honorable Supreme Court in GlaxoSmithKline judgment, and this is not maintainable, the entertainable, Your Lordship. Sorry. I mean that second, that because Panigai judgment, both the judgment, Your Lordship, 169 1D is a valid service. And delay and latches since cannot extend it so far as the appeal is concerned. And in the because Panigai judgment, also Your Lordship has recognized the judgment of Honorable Coordinate Bench as well as Honorable Supreme Court in GlaxoSmithKline judgment and dismiss the writ petition in both the cases, Your Lordship. So the petitioner cannot allege that it was not within his knowledge.
3.3 is the reason. He could not know it is of.
My lord, here, your lordship, my lord, this honorable court passed.
Your lordship, 73 orders in the 73,
Yeah,
not, it
your
is not the order that his RC has been cancelled. Sorry, yeah, I did it. There is no.
Your lordship, kindly have a glance. I am passing the three judgments of this honorable court and the honorable Delhi High Court, and the tax is for the period 2017-18. It is also a time bad, and Supreme Court is in the sessions of the matter where this notification of 2023 is under challenge, and Delhi High Court passed similar orders. I have passing those orders. That's the Delhi High Court has passed that matter is sub judice before the Supreme Court. It is a time bad matter. They have issued in 2022.
Whatever in Ravindra Surgicals Private Limited, we have held that, in Vikas Panigrahi matter, we have already held the delay matches, this bench itself. So we are more bound by our own judgment than a judgment of a division bench.
And I have passed on the division bench judgment of this honorable court. Where
No,
this honorable court
this is
has
what
passed.
our own judgment is there. Can you argue? This is the
lord,
judgment.
No, my lord, that matter your lordship is showing that is also not considered, that is regarding time bad. It is a time bad notice, and that is sub judice before the honorable Supreme Court in regards to notification of 2023 extending the time for demand. That has been sub judice before the honorable apex court. I have passed on a Delhi High Court judgment where they have also remanded the matter to the appellate authority to consider, follow the principles of natural justice and pass appropriate order. Looking at the Supreme
Your
Court order.
counterpart has not given us the judgment. Where is the judgment?
168.
Our Delhi High Court.
168.
My associate is there, my lord. My
Your
associate.
associate is simply standing, not passing on that judgment.
Kindly pass on the judgments to the honorable court. Pass on the judgment.
Where? Oh, this is a Odisha High Court judgment. This is
And
a
last-
Odisha High Court
in that-
judgment. This is a
No, you
Odisha
lord.
High Court judgment. Where is the Delhi High Court judgment? He is referring.
My lord,
Where is the Delhi High Court judgment? He is referring.
I have given a bunch of judgment. In the last judgment, after Odisha High Court 2 judgment.
Sir, where you have given a bunch of judgment? All the Odisha High Court judgment is given. Where is the Delhi High Court judgment?
The last one is Delhi High Court. In that
Where is that?
one chapel, there is a Delhi
Where
High
is
Court
the
judgment.
Delhi High Court judgment?
Delhi High Court division bench judgment. If it is passed in violation of the principles of natural justice and it is a time bad matter, as per the Supreme Court judgment, they have referred to the Supreme. I am reading that part of the judgment.
That is not applicable. Your Honor. That notification.
Yes, it is applicable.
Acha.
That is also a section 23 application that was considered, and they have challenged the notification of 2023 extending the period of demand more than the stipulated period, and accordingly the Delhi High Court in the referring judgment, I am reading the para 8, page 4 of that judgment. The court had hired learning counsel for the parties for a substantial period today. A perusal of the above would show that various high courts have taken a view, and the matter is squarely now pending before the Supreme Court. Apart from the challenge to the notification itself, various counsels submit that even if same are upheld, they would still pray for relief for the parties as the petitioner have been unable to file replies due to several reasons and were unable to avail of personal hearing in most cases. In effect, there is most cases the adjudication orders are passed ex parte. Huge demands have been raised and even penalties have been imposed. Broadly, there are 6 categories of cases which are pending before this court. While the issue concerning the validity of the impugned notification is presently under consideration before the Supreme Court, this court is of the prima facie view that depending upon the categories of petition, order can be passed affording an opportunity to the petitioner to place their stand before the adjudicating authority. In some cases, proceeding
You are referring, he is taking a plea of a delay in laches. Please refer, you are referring a Delhi High Court judgment. Have you seen? The Delhi High Court was considering a writ petition filed in the year 2024 assailing the rectification order which was also passed in 2024. So there was no delay in that sense, and the court has said that the rectification application without giving an opportunity of the hearing having disposed of, that violates the principle of natural justice. And what was the direction? Direction was to hear out the rectification application afresh by giving an opportunity.
Yes, that is the demand show cause notice of 4th December 2023, challenged in 24.
Sir, it was so within 1 year, sir. It was not, it was done. Look at the challenge and the ultimate relief.
Yes,
Then he said, does the rectification, when the rectification application was dismissed? It was dismissed on 30th of July 2024, and the writ petition was filed in the year 2024 itself.
No, that was
Must be,
challenge to
and that was decided on 3rd July 2025. That means 2024 the writ petition was filed, and the court has said that the rectification application filed by the petitioner is restored to its original number. The order dated 30th July rejecting the application filed is set aside. Give a notice and then decide the matter in presence of the
because if it is a time bad proceeding,
there was no delay.
May I pray, my lord? May I pray, my lord?
That case we have already said the delay.
My lord, because
He's sitting over the matter for a pretty long time. And
No, my lord, because my lord, it is matter is sub judice before the Honorable Apex Court. It is a time barred demand. It is ab initio void. It can be challenged because it is a time barred demand and matter is sub judice before the Honorable Apex Court.
Sir, then if you know everything, then why you were sleeping in a slumber? When it was passed in 2022, have you not to file a return in 2023, 2024, 2025? Have you not?
No, that was not.
On a portal, immediately will you not come to know that this order is really there, uploaded on the portal? Why you did not challenge it in 2023 itself?
I am always not verifying the portal. How I can know when they this? My lord, when my account was attached, I came to know. When my account was attached, I came to know about it. Thereafter, I found it that these are the things they have done. My account
What
was
is the
attached.
system it works? They have to upload the portal and then upload their subsequent return. And the moment if there is any outstanding demand, I think it must pop up. So,
That is
is popped up or not? Not popped up.
There is another issue that at that time, they have on portal there are two windows. It was coming in the additional window.
that was in the instruction itself. That was in the instruction itself.
As per the instruction, that has to upload service, notice and services.
Queries before filing at the time of filing the return for the subsequent period, whether any mechanism is provided in the portal to know the outstanding or any other areas. So, for the previous period.
That may not be. What was the system? What was the system?
We are trying to understand. We are not having a direct knowledge of that. After departure, the GST regime came. At least I can share. After my departure, the GST regime came.
Only clarification I have.
There is no occasion of approaching the portal personally by me.
Your Lordship, only
After that judgment of
Madras High Court, after 2002.
that additional menu, I may say, that is deleted and that is merged into one.
Because normally what happens because it has the same GST number. So the moment you have to upload your return with that GST number, if there is any pending demand, I think immediately it should give a pop-up on the screen that this is what is the demand. They will not prevent you from uploading, but at least showing that there is an outstanding demand.
Nothing is coming.
Is not there, but that should be the good mechanism immediately.
But not for
in fact, at the time,
You see, sir, just one reason. 3.3. And
Should not know
he
about
has
the
he has not
notice.
stated the date on which it has come to his knowledge.
Your Lordship.
He simply said that bank account was attached, but he has not given any date on which the bank account was attached and it has come to his notice.
Has he annexed the order of attachment?
He has not
No,
challenged.
Your Lordship.
He has not
He has
challenged.
not. So that's a vague. The
Vague.
knowledge is also vague.
Your Lordship.
That's why.
Then in that event,
Your Lordship, let me clarify the system. What happened? Once we have uploaded, department is uploading, the portal is uploading, so far as the any notice or order, anything. Your Lordship, a pop-up will go to his registered mobile number and another pop-up will go to the
it's
registered
not a
mail.
pop-up, it's the information of the message goes. Huh?
Information will go that a notice has been uploaded in the GST portal for the period launched. Simultaneously, so far as the registered mobile and the registered email ID.
Emails.
Your Lordship. So after that, Your Lordship, he has to open the portal.
I understood.
And Your Lordship, he has to comply.
The fi- because the final order they have passed in 2023. 2023 they have passed. Now because I have the work contractor, several monies coming to my account, I could not pay because now I came to know that it has been attached. They have attached it. And no message intimation given to me.
Will you not disclose the date of attachment? Will you not disclose the order of attachment? Will you not disclose the communication made by the user to you that your account has been attached? A vague assertion. When you came to know on the attachment maybe of 2022, maybe up to 2023, we don't know. These are speculation. When the attachment was
file
made.
additional affidavit. I will file
Well,
additional
you can't.
affidavit. showing
Additional
the-
affidavit?
I will file additional affidavit.
No,
Let it come
nothing,
next
sir.
week.
Yes.
No, because they have attached.
Yes, sir,
it,
we'll
that
pass,
then I
we'll
will
pass
do.
the order.
Paraphone.
Yes, 6.
Is put under the Orissa Suspects Act for the period 1997-98. Here, the dispute was related to the pursuing the BSNL with the government of India.
Why you are challenging the show cause notice?
Yes, my lord, that I have challenged.
Why? You know the scope of writ under the, so far as the
I'm
show cause
just trying
notice
to
is
give you the
concerned.
background. That there is a demand of the suspects. The assessment was there in
You
2000.
go there, the authority may
Just kindly wait.
drop the demand. You go there,
No,
let them
kindly-
decide.
Just I'm giving a brief fact.
Can raise all the objections.
Yes.
Here, my lord, under the direction of the Honorable High Court, assessment was completed and assessment was dropped and demand was made. Subsequently, they initiated the proceeding suo motu revision proceeding. That is, my lord, have a glance at Annexure 3. What is the ground? Kindly have a glance 46, page 46. The present select place. Present initial revision proceeding involved following grounds.
Not justified while adjudicating.
The nil demand is not justified while adjudicating the respect of rental charges received by the BSNL from its customer. And the London STO has committed error while interpreting the judgment of the Honorable Supreme Court in the case of the Bharat Sanchar Nigam versus and others reported in 145 STC 91. And the telephone rental charge collected by BSNL in the telephone bill is the charge of rent made received toward the telephone set supplied to the subscriber is coming with the ambit of the sale and defined as the of the STI. So this was they have initiated the suo motu revision proceeding. That is under Rule 80.
What?
In response to this, I appear and file a preliminary objection.
Yes.
So this is barred by limitation. So to cover up this, now they have come up with a rectification petition. So whether revision and rectification, scope of both, in rectification, what the same issue there, that is at Annexure 4.
So you place those points before the authority. What is the difficulty? Raise the question of jurisdiction. Whether you can simultaneously proceed with all those matters. These are the questions you can raise.
How rectification scope, it is a very disputable issue. It is about a
You raise that point. I understand. Ultimately, if they pass an order, you have a
Judgment
remedy.
of our court and Supreme Court.
So show cause has been set aside.
Well,
I'm asking whether in those cases the show cause notice was challenged and set aside.
what is the scope of Rule 83 already decided by the Supreme Court?
True, that is what the
And
merit is
they
concerned.
have passed the notice.
Show cause notice
My lord.
shows that it was entertained at the show cause level. I am more concerned with the show cause. Because I tell you, I am bound by my own judgment.
And
There.
I have got.
I have my own judgment.
And that is their income tax. Sikkim.
Yes, because authorities have not.
Justice, just one thing.
So was noticed that royalty
So the coastal container case has followed and other, many other cases.
I'll give that. And see the royalty, that was related.
That is Mitambani.
I get me.
Mitambani is something different. No,
That is Mirambika.
another-
Miram
Mitambani is under
GST.
that is GST.
Para 8, my lord. What is the scope of 83 already Supreme Court has decided that.
Sir, this was against an order. Again, I am saying, if you look at paragraph 2 of this judgment in Master Construction Company Limited, what has been held is that there was an issue relating to the refund of an amount. Then on January 5, 1963, the commissioner issued a notice to the appellant under Rule 83 of the rules, calling upon him to show cause why the order should not be reviewed. Ultimately, on September 24, the order was reviewed. And that was the subject matter of challenge in the writ petition which went up to the Supreme Court. So the merit can be gone into if the authorities have already decided a particular issue. But it is at the stage of show cause.
Because already matter is settled by the
No,
Supreme
sir,
Court.
there are very limited scope. So far as there are very limited. What I have held is there are 2 or 3 grounds when the court under Article 226 can interfere with the show cause. First ground is that the authority who has issued a show cause notice is completely incompetent to issue that notice. Second thing is that the grounds which is enumerated is so ambiguous that it cannot make out anything that what the authorities wanted to do. Apart from the same, I think the scope of interference, because they have to apply their mind, they have not applied their mind.
Here they are going to interpret the full bench of the judgment.
Maybe
It's a
they
excited.
interpret in a correct manner that goes in your favor, that may go in your favor. Why you are prejudging? Mere issuance of the show cause does not mean that the authority has prejudged an issue. They will give you an opportunity to file an opposition or the reply, and thereafter they will definitely give you an opportunity of hearing and decide.
I don't know what is the. Then you have to come up with.
Then you can come for a challenge on that ground, but not at the show cause.
Well, revision and rectification cannot, because they are going for the revision. And when was
You can take that plea that you cannot go simultaneously with both.
kindly have a glance what he has made here. He is mentioning they have problems.
You can take that plea, let him either rule out your contention or they may accept your contention also.
No. Now they what are they telling? They have the revision is dropped. After my objection, they dropped the revision. And they're telling now rectification is going. Additional commission kind
So
of.
you take that plea that you cannot take recourse, is time barred, everything, you can take that plea.
For time bar, they have already dropped. Kindly have a glance to Annex 7. But what they have mentioned the drop. Additional commission mentioned because rectification has been started, so we are dropping that. So how
So that is
rectification and revision will be.
So you take that plea, how can you go raise a plea of demur? Take a plea of demur. No difficulty. Let him decide.
They have not decided, they will immediately pass the, we are raising a plenary objection.
Sir,
They are being very.
let them pass an order, then you come and challenge that whether they can do it or not. Then we will able to interfere. but not at this stage when they have not applied their mind.
Are already there.
No.
Simultaneously, because they could not pass the order of the revision because time varying. So immediately they come up to the rectification.
Correct. So these are the things you can brought to the notice. There is no difficulty. This is available to you in the reply. Have you filed a reply to a show cause?
Now, I filed a preliminary objection that you can't, because revision is pending, so you cannot go. So
Now
immediately
they have drawn. So you can definitely take
That has been
raise that.
disposed. The preliminary objection of the jurisdiction, double proceeding, that has been decided that there is no proceeding as page 59. That there is no proceeding pending so far as the revision
small, page 60. What is the order?
We are not challenging that order.
not challenging. And accordingly, Your Lordship, he has given another opportunity to provide all the documents in continuation of the original notice, Your Lordship. So let him appear and raise all the grievances, all the
They can
grounds, Your
open the
Lordship.
Pandora box. With only garb of the rectification, they are reviewing the order.
Oh, you take a plea is a question of malafide, the question of malice that would come. You can raise that plea. There is no bar that you cannot raise that plea. No show cause, brother. Where is my judgment? And I do not think your judgment is also.
My Lord, your Lordship.
That even on this.
Discriminations.
This is what I actually.
Well,
Is that thing.
here 263 order and 154 order. But here, my Lord, first paragraph, my Lord, just this first paragraph in your, my Lord, the second limit is also applicable. The challenge is further made on the ground that the appellate tribunal which stands on the higher pedestal, in my case, for other period, already tribunal has decided in my favor. For other period, already tribunal has decided in my favor. That order is also not.
The higher of the has already passed the order, they decided where the opportunity
How we can do that high authority, whether we can change the order of, see that order of the higher authority.
So when the order is because how they rectify?
The,
Now,
now
now
subject matter of challenge, there was already an order passed by the chief commissioner, which was challenged there. So that is what I had a occasion to say everything, in
so will
that way, I had said that, cannot be. And the plea of res judicata was not to be taken, which I said in a taxation matter, the plea of res judicata does not apply.
here is not a fact.
Every,
Here is a question of law.
final for that assessment.
But here is a question of law.
But then again, you go and
Recently also, Apex Court has given in 2026 in the case of so-called also.
for very limited scope.
With a so-called-
limited scope.
But
Is background story, not irregular attitude. He has the jurisdiction, exercise of power.
challenging his jurisdiction.
I can again say, if you say that the authority was issued last jurisdiction or is not competent to issue cause notice, definitely what you say, the court will interfere. But not in a case where he has, but it's a wrong assumption of the interpretation. Then in that event, you can definitely go there and take a plea because it depends upon the nature of the defense which you wanted to take in your time. Indian judgment for the show bar will not.
Well, 2026, Mr. Parliwala judgment is in our favor. Not Justice Nath.
That is what it says, jurisdiction.
And abuse of process of law.
Oh, deriving a notion from Justice Krishna Iyer's judgment of 76 Supreme Court. Adivandanam, or what is I always Adivandanam, Adivandanam, or something like that. Adivandanam.
That is,
Honestly,
11.
Abuse of the process.
Regularizing their revision limitation, they are covering that with rectification.
it's fine. In course of
Against patents. Against patents.
no.
Supreme Court judgment.
Yeah, let's- In course of I'm sorry.
No, sir, if the council appearing against you has come and then you will not prepare yourself to match.
This time, this is the lack on my part.
But to question. The Bhubaneswar Development Authority of this board. The service action. Service of Indian. National Renewal Company. These are all the places we have. And there also we have discussed about quantum jurisdiction and irregular assumption of jurisdiction. Central Potteries and Deepak Agro. Okay.
So we may also kindly give application.
We'll extend the time for writing a reply. If we think that will not entertain, then we'll extend. Will we entertain?
So can I give the judgment, other judgment also Supreme Court?
What? Those are the judgments I don't think whether it is relevant or not. The point is this
Order.
scope of the 226 against Ashoka. If you have a judgment, give it. Against Ashoka. Yes. Next week for orders.
Number 7.
It is the first appeal order, Your Lordship.
No, just that.
Yes, the tribunal is
Just
now
allow me to.
active.
First of all, I'll move back here.
Prayer, Your Lordship, may kindly look in it.
Well, here is the case for this year 1718. So there are certain works control executed prior to GST regime, and there are disputes with regard to the GST. Well, here I'm challenging this 74. They have challenged. Here I have appealed the entire tax, 100% entire tax, and for the interest and penalty, they issue the notice under 74. That is my.
Because that is what a very uniform stand which we have taken. That previously there was no functioning of a tribunal, so we were entertaining all the remedies.
Hello.
But now they have come up with a notification of a circular where they have extended the period of regulation. I think you are still within the period of
30th of June.
30th of June. So you can definitely buy the machine.
But here my Lord has power on a 75 too. It can be converted to 73 because it's for the interest and penalty only. So if it is converted, the party will go in amnesty because they have issued the 74 because I have already paid the entire tax. After payment of the tax, they issue the 74 notice. Only for interest and penalty.
Interest
Interest
on
and
section 50 and penalty under section 70. Now also he has not to deposit any fee deposit. Your Lordship, since the inter-tax conference.
Tax I have already paid.
That's why you say.
An order has been already passed by the Ventilation bench. This is an identical matter. So, for the same petition, but for the different assessment. Here. We have challenged the tribunal order.
Your Lordship. The interlock.
The BIFR or CICA
You'll see preview.
That was under the RBC.
Went up in appeal.
It is from IBC. It's not that case.
Has been challenged right now in Supreme Court. That all right.
No, subsequently, it is not that case. Previously, it was before BIA. Before BIA. Subsequently, during pendency, the proceeding before BIA, his turnover was surplus. So that proceeding, that order has been passed by BIA by revoking that previous interim order. So subsequently BIA has come. Your NCLT has came in. So then that order of BIA has been challenged before NCLT. So these are the assessment order during pendency of that proceeding before NCLT. Assessment subsequently first appeal before the tribunal. And while pending before the tribunal, they have placed for interlocutory order. So the tribunal has passed the interlocutory order by observing that since the matter is pending before NCLT, so the matter may be kept in abeyance. In the meantime, that order has been challenged here in this writ petition. So subsequently, NCLT has passed the order by confirming that that order of the BIA has confirmed.
Mean appeal gone. Mean appeal pending before NCLT is gone.
So now it is the tribunal with the appeals which are pending before the tribunal is to decide. So now this interlocutory order has gone in Tokyo's Your Lordship, pursuant due to the disposal of NCLT. So accordingly, my lord during vacation bench has passed the order by directing the petitioner to raise all the points before the tribunal and the tribunal to decide the issue. Exactly.
So there is no longer there in existence.
Similar order, Your Lordship. Only Your Lordship may not target the appeal, may not fix any date because full bench is not functioning. Your Lordship, not target. Your Lordship. Great.
All the things.
So the last is
Item 9, Your Lordship, this is pertaining to section 73(4)(b) of the Finance Act.
Item 10.
Challenge the initiation of proceeding and completion of assessment against a deceased proprietor, even if the legal error has been amended in the registration certificate since long, but they have proceeded against the deceased proprietor. As well as the appendix 2. The death 24/11/2022, death of the proprietor. Page appendix 2. After the synopsis.
Mark, my lord says B.
synopsis.
Page B. before 11/2002, death of the proprietor. 01/2023, intimation to the department regarding death of the proprietor while applying for 45. January 2023, intimation to the department regarding death of the proprietor while applying for new registration.
My lords, what has happened in this case, my lords, they have obtained a new registration stating the reason that the proprietor has expired as a partnership for in the capacity of partnership.
They say the proprietorship concern.
My lords, but that same GST number is also continuing till date, my lords. They have not cancelled that registration.
And why not cancel?
My lords,
You have not
intimated to the department.
no, my lords, for a moment, my lords, they have filed an amendment application for changing the proprietorship firm
Concern into a partnership firm.
That is, my lord, that is one aspect. Second, the same registration number is now being run by a legal head. The legal head is filing the returns till today, my lord. The registration is
We
active.
are filing nil returns.
They have participated in the
Completion of the all proceeding. We are filing nil return. We are not doing any business in that area.
They should have cancelled, man.
If you have inherited, then in that event, even if that is there, the returns, nil returns are filed by them, then will you not issue a so-called notice on them?
To the legal head, not to the deceased person.
At the behest of the heirs, then will you not give them a notice?
My section 93, my lords, kindly.
That only,
Yes.
as I have quoted, page 13,
Only section 93.
93. I have quoted my husband. That is regarding recovery, not assessment.
That's section 93, 1A, my lord. I'm placing, my lord. If a business carried on by the person is continued, it is important, it is continued after his death by his legal representative or any other person, such legal representative or other person shall be liable to pay the tax.
No problem. But only kindly consider, there is a distinction between the liability to pay the tax in respect of his deceased sons, his predecessor,
No.
and the initiation of proceedings by issuing a show cause. If this section recognizes their liabilities, then we can issue a notice on them and say that there is no liability. Liability he cannot deny.
Whereas when the show cause notice was issued, they participated in the assessment proceeding, they produced the legal representative, produced the books of account. At that time, whereas this question of objection was never placed before.
In the reply, we have mentioned, we are replying as a legal head of the deceased proprietor.
Representative,
We have mentioned legal head. That is, I have already annexed.
my lord, kindly see page 70. $69 million.
Yes.
Record of personal hearing. Mr. Shmuti Ranjan Swami, accountant and authorized representative of JS Enterprises, attended the personal hearing in virtual mode, and he reiterated the earlier submission to the SCN. In this SCN, he produced only the books of account. He never objected regarding the initiation of the proceeding.
Come to page 120.
Yes, ma'am.
So once you are aware of the serial number 2, at serial number 2,
You have given in the personal name He's talking about the proprietorship concern. Notice is given in the personal name.
And you have recorded, you see, the text, sir, respectfully, I so and so, legal so and so, attached here with all explanation regarding all query.
Yes.
So there also you are aware that serial number 2 person is not, no more in this world.
Yes, my lord, that has, they have intimated.
How can you further?
Notice is the foundation of proceeding. If the foundation goes, whether the person can remain in error.
My lord,
There's a legal maximum on that also.
There also says 129. Again,
What is that? I don't know, this subplant 2 or something like that.
Let see 124 page. So when we file it, we will return.
no petition I always find.
Legal.
No petitions I always find. Subletter said it,
What is that?
the foundation goes.
Sublato fundamento cadit opus.
Foundation removed, superstructure.
No, I always find in your written notes, I am acquainted.
My lords have already decided similar issue in case of service tax. And also series of decisions are under the GST Act, Notice would have been issued on the
Legal aid.
legal air, not on the proprietor, it doesn't cost.
In income tax, we have one judgment, but distinguishing. Because in income tax, that provision is not tax, I think Mr. Gaurav was asking.
Good.
Sabina.
It's a Konaklata Sanat.
Provision, my lord.
Sabina decision has been quoted in that.
1922 was applied in Sabina, not 61. In 61,
That is
there was
related on that.
an amendment. So legal, there also legal errors have to be noticed, then proceed. Here, entire succession. You are appearing, no?
Yes.
In that case.
There is the different services, there was no provision, here there is a provision.
A provision for recovery, not how to proceed with the assessment procedure.
You will see. You are the housing.
Service tax, my lord, there is a provision.
Mr. Paul argued. You were opposing him.
But here there is a provision, my lords, and my little some humble submission, limited submission, my lord, they are still filing the returns, the GST number is active.
I am asking you, sir, where is the problem? It says that even if the proprietor is dead, or a person is dead, a notice can be issued in his person name. I will say, you have referred to section 93, where the liability is.
Recover the money.
They cannot escape from
Not
the
how to proceed with the assessment procedure. That is not.
The very, very basic fundamental principle is that one who inherits the asset must also inherit the liability. That's a very fundamental principle. So that is their found. It does not mean that the proceeding has to be initiated against the dead person. And even if you
It's there, my lord, just business is still continuing, the only limited submission I can.
I understand, sir, that you could have issued a notice in the business name. In the business name. Where was the fault on your part? Where is a obligation? You could have.
It's not your case that you have not been intimated or you are not notified.
What has happened, my lord? They have taken a different new GST number stating that the proprietor
Different entity in relation to a different entity of business activity. The different, you have no issues. you are concerned with this entity. So now this entity, they have already intimated to you that my father has died. He be as a legal heir or a legal representative. The word is very correctly, aptly used as legal representative in this section, not the legal heirs. If they are a legal representative continuing with the business, then they are bound. They're bound. What is out there? Their liability is there. We can't escape.
It is 73 proceeding.
Well,
73.
73. Then time bar.
not.
Why not?
You will not say.
No, not time but.
Assessment ever notice the level.
Operate. That is left open.
In pursuant to your lordship direction that
will cover 2 years.
So direct will appear, no problem. And the ground of demand, 99% invoices, purchases are from dealers those who are using e-invoice. And in e-invoice, there is a ARN number, and the demand has been raised. The ARN number is not available.
and factual.
On merits, you are.
But it is 100% available. But it is system generated, investment system generated. It is there. But making allegation because there is no physical hearing, order has been passed.
As they have just intimated that regarding the death of the proprietor to amend the status of the fund. They are now operating as a legal heir in the same GST.
Now again, I'm looking at question this word legal heir from where you pointed.
From the document they have managed.
Can there be any heirship without any legal provision? Is there any concept of illegal heirs? Heirs means a legal heir. Heir means an heir. Legal representative that comes. That's why section 93 was very clearly worded. Does not talk about the heirs, it talks about the legal representative. Look at section 99. So it's a term of difference between an heir and a legal representative.
Regarding time,
Continues after his death by his legal representative or any other person. Never use the word heir there in the section.
This is proprietorship.
Or she may remand the matter, my lords, to.
Remand.
No, because the foundation itself is defective, sir. What is the starting point of an initiation of a proceeding under section 7? Because
My lords.
if it is the starting point and the foundation is faulty, then remand. Remand means rehearing on the basis of that faulty foundation.
Now, who will appear? Who will appear? You will remand. Whom to ask to appear?
Issue to the legal representative, my lords.
Why? I will substitute.
My lords, they have filed an amendment application by the legal
Of
representative.
course, you have to take substitution.
Whether the RC, my lords, I will take that instruction, whether the name of the legal representative is present, available in the.
My lord, pardon to mention, is the BSL matter, other 7 matters there, I'm giving at least 7 similar.
One matter fixed for 2 p.m. Supplementary, sorry.
Yes, please. And I'll file a small note by Monday.
Supplementary list item number 1, matter fixed for 2 p.m.
See, the same, I placed the matter. And first on the serial number 2. Same. Sorry.
Who does supplementary?
Supplementary of August.
Supplementary one, the fix of 2 p.m.
I'm so sorry, but I'm so sorry. I thought that especially mentioned matter. I'm so sorry, but I beg excuse. Yes, yes, that's that.
This matter was yesterday in the list, also directed to obtain instruction with regard to this tender. And whether matter was placed before the expert committee. I've obtained instruction and hurried now file an affidavit to the stating the entire sites also.
I know.
My lord,
And the affidavit, I will show the copy
my lord, my
on the
humble,
other side.
my humble submission is, my lord, the dates are fixed to my lord 29th. Your lordship has already observed about this fact. And that's why, my lord, the matters are posted to today, my lord. And they cannot, my lord, justify something by bringing on record which was not there when the impugn order was passed. That is a settled principle of law, man. Whatever evidence, what are those documents he has relied upon and passed the order, he has to rely on that only. Now he cannot develop the case by bringing on record something.
That is not.
And it
Petitioner has quoted 32.70% less than the
yes.
project price last. Will also
We have amended the rules that concept of 15% has been
no, we also
done
can
away
see
with.
the also
That has
can see
been done away with. Now you can take advantage.
now in also in view of and we also can turn to annexure of my applicants have given this to him. He has also annexed that. Where the
What they have.
they have also annexed. The office memorandum dated 3/1/2026. 3/1, page 77 of my affidavit today. Page 77. Yes, you can. It was placed earlier, yes?
Yes.
Yes. Page 78, paragraph 6. Justification for abnormally low bids are scrutinized by the departmental technical committee and recommended to the competent authority for the administrative department for approval of the additional performance security. An abnormally low bid is one in which the bid price, in combination with other elements of the bid, appears so low that it raises material concern as to the capability of the bidder to perform the contract at the offered price. Procuring entity may, in such cases, seek written clarification from the bidder, including detailed price analysis and its bid price in relation to scope, schedule, resource mobilization, allocation of risk and responsibilities, and any other requirement of the bid document. If after evaluating the price analysis, the procuring entity determines that the bidder has substantially failed to demonstrate its capability to deliver the contract at the offered price, the procuring entity may reject the bid proposal. However, it would not be advisable to fix a normative percentage below the estimated cost, which would automatically be considered as an abnormally low bid. In view of the clause, the petitioner wants to substantiate how it is practically feasible
And accordingly, 3 times given opportunity and 3 times she has failed to satisfy the committee. How with such a low amount he can execute the work? Thereafter, matter was placed before the committee has taken into consideration and given a very rigid order.
That was never mentioned.
That is,
You are not in all that is and my lord, after my bid was accepted, my lord, it was held as L1. I was, my lord, asked to, my lord, give my justification about some details, my lord. That is under Annex 1. And I give the detailed report, my lord, with all supporting documents under Annex 2. Thereafter, my lord, I was directed to place on record the price analysis as to on what basis with this price I can do my work. A format was also included therewith, a format. In the format, my lord, the clauses were there. I filled up all the clauses, justifying that I have the sufficient resources and this amount that I have quoted, I am prepared to do the work within the time stipulated and within the standard that is fixed also. And also I submitted that so far the expenditure toward the procurement of the raw materials is concerned, particularly by the stone builders. I have a stone quarry unit that I have obtained from the state of Orissa, and that is valid till 2029. I have also a stone crusher unit for preparation of boulders and chips also. I have also sufficient number of vehicles like excavator, also minor dumpers, and other tippers. All the materials, man, those are required for the purpose, man. Thereafter, my lord, under Annex 5, they are asking me to agree for extension of the bid validity period. They have not questioned the reply that I have given, my lord, as for the price analysis report that they sought for me. I submitted that. They did not dispute anything about it. Rather, they are under Annex 5 asking me to be agreeable, my willingness to extend the bid validity period so that it can be extended. Immediately, I submitted my response saying that yes, I am prepared for bid validity period and I am prepared to do the work. Then also, my lord, they questioned that you have given the order of the State Pollution Control Board with regard to the consent to operate the lease area for the query purpose. But where is the lease agreement? That also I submitted. Here also I have submitted a copy of that under Annex 7. Despite that, my lord, they passed the order under Annex 8. They quoted the prices that I have given vis-a-vis the price they had, my lord, they had stipulated. And everywhere it is low. First clause, they are saying that you have given you own an excavator, but there is no fitness certificate. My humble submission is that an excavator is used only for the work purpose. It is only confined to the work area. And recently also the Honorable Supreme Court has said that it is not a motor vehicle that it needs a registration, motor vehicle registration, because it's not run on road. And the manufacturers and the suppliers also, they also have to provide any minor certificate with regard to that. Where it is confined to that area. This asking for fitness certificate is not required at all because you are giving me a work only. You are not bidding for each individual item. And you are pointing out something which is not required for you to take into consideration because my job is to execute the work and give the delivery of the work within the stipulated time. And they are asking, pointing fault on the excavator, which is not required at all. And also they are saying that you may be violating the minimum wages guideline. My humble submission is that because I possess the machinery smiler for production of boulders and chips smiler, and that is produced by the machine. If I had required 10 laborers, or in this case 7 laborers work is dispensed with the machine miler. So if 7 laborers work is dispensed with my machine work, I need only three laborers or 4 laborers, and I'll pay the laborers they are engaged by me the wages that is stipulated under the law. And they are making a misconstruction that I may be violating the minimum wages law, which is not a fact also. And my quote is about less than 1 crore of the project cost they have mentioned. It will save the revenue of the government for 1 crore. And I am consciously quoting this because I am a graduate engineer for more than 20 years of experience in this field. There is no adverse remark against me. And I know also that if I don't complete the work within the stipulated period, I may be liable to face problems related to my own livelihood. I may be blacklisted also. I know the decision that I'm taking consciously. I'm not making any big kind of preparation to put anybody into problem and ultimately to put myself into problem. And in all these findings, my lord, they have outright rejected. Yesterday also, my lord pointed out, this is all your speculative. These are all subjective. What is the objective finding also? And because government took into account that people giving the less, there is a heavy competition also in the market. That is why the contractor, they are bidding at a lesser price. And they are able to do the work within the quoted amount. That is why earlier when it was 15% less, they have abolished that. They are saying that any amount you place. And they are inviting everybody. And my credential for last so many years, they can find out also. When I purchase all men, machinery, resources, everything, what is the problem for them? And this will, and if they outright reject like this on their own basis, without any disclosure, I'll give it point wise. There is no respect. I can submit also the ground they have taken while rejecting my application. Excavator, it is not, there is no fitness certificate. Where it is not required, law is laid down also. Recently also in 2026, the Honorable Supreme Court has said that. And so for the pollution certificate I have given my lord, it is obviously after the lease is granted that they have taken a ground. And regarding my lord, the minimum wages also that I say that I will give as many laborers I pay them as per the mandatory law. And last time also it was pointed out while looking into that government office memorandum that when the bid is less than 20% of the quote, the price bid, they can obtain additional performance security. Many securities they will obtain from the person. The security will be also forfeited if somebody defaults in working the work within the stipulated time. I'm prepared to comply with all those conditions also. I'll deposit everything also.
is. What was the utility of keeping this? You have simply reiterated what your committee constituted by you have expressed. Nothing more than that you have done. They have annexed all the documents.
Yes.
That's good for you that you have been able to prepare it.
No, we have considered 4 bidders, not only one petitioner. 4 bidders, those who have given their bid price below the project cost. What they have,
Why?
each and every person who have taken together.
Said that, so if it is quoted below 20%,
Yes.
then in that event, the evaluation has to be done.
Yes.
Just to understand that whether it is feasible for them to do it or not to do it.
Yes. No.
Now, this is really a subjective evaluation in that sense.
Yes.
If he has given us a configuration that, look, I have the stone quarry at the arm length distance, I am having it. I can use that particular stones at a very cheaper price. It is between a willing buyer and a willing purchaser. Who are you to adjust and decide it?
Now, question is whether it is subject to satisfaction of the
What is the subject?
question the line.
There should be. He said that it is not that I am buying from somebody else.
Yes.
Had he been, then he should have shown the contract which he has entered into a third party. He himself is a licensee or whatever.
You will get the benefit of
permit holder of the stone quarry, and the stones he will use from his own quarry.
All these things have been taken note of by the committee.
What all these things? Only labor.
No, only labor, not only labor, ministers. All other things also, ministers. The transportation of
It's the government who will be benefited. If the government has to spend a lesser amount, and he has said that I am working in this particular similar nature of work since last 20 years, he has shown, he has given the details that I have done here, 4 places, 5 places, and not even an iota piece of evidence has come that he has not done the work or he has left the work unfinished.
Government will ultimately benefited if you will do the work. Question is that
why taking so much of
he is ready to pay the performance guarantees.
He is ready. He says that if it is a requirement under the conditions, additional performance guarantee, I am ready to give.
Additional performance as below the 20%, the apprehending that
tell him that what would be the amount of the guarantee he will pay.
If it is some other day, I will take it. No, he is there, Milord.
Secure yourself.
Page 15. Page 15.
Yes, what he is submitting that we cannot take the additional performance security more than the provision for that purpose. The provision is that.
Sir, what is the purpose of the additional performance guarantee? Performance guarantee.
Yes,
that
yes.
means if the contractor fails to perform his obligation,
Yes.
at least the government will be able to realize that particular amount to compensate. So they are ready.
That ready means the performance guarantee, what he will submit as per the requirement, that will be much less than the amount.
Sir, please, in your office memorandum, 3/2026, page number 15, annexer B/3, which you have enclosed here.
Yes.
Clause number 3. Your case is less than 20%. In your affidavit, you have said.
Yes.
So
Yes.
the consequences are there. What will you do? How will you proceed?
This will be much less than the percentage of work he will do below the work. It cannot be recovered. It will be much less. That is the reason why we say we will not be in a position to recover.
Able to fathom what your authorities have in their mind. It does not say categorizes that up to this limit. It says less than 20%. It may be less than 50, it may be less than the 30, it may be less than 40. It does not quantify it.
Because of
If
that,
you
this is
say
why they are
that-
apprehension. Because of that, they are apprehension that
What is the apprehension? I am really unable to understand.
There are apprehension that
What
they
is
may not be in a
the-
position to recover the amount from.
We have seen several judgments of the Supreme Court. We said that what is the purpose of floating an open tender and inviting the application? What is the object? Object is not only to show the fairness, transparency in the process of procurement, but also to achieve the best price.
Exactly.
So that the government exchequer is not burdened in any sense. If a person has quoted a price and he says that I am able to do it, and he justifies his reason, 2-3 grounds he has given, then in that event, will you not come with the subjective satisfaction of it? You simply say, I am really amazed how he can do it with this price. It is his baby. It is his responsibility. What you will do? If you say quality compromise, how do you know? He has said that I have done the similar nature of work. Is there any allegation against him that he has compromised on the quality? Have you been able to ascertain any such aspect? Any document?
That is not
there. How can you presume? Sitting in a couch in an air-conditioned atmosphere, you think that he cannot do it. Is it a subjective satisfaction? When he's saying that this is the price, I will get it.
What is submitting that document he has not furnished with regard to quality. What quality he will maintain with regard to that, no document, supporting document he has not given. That you can ensure.
Sir, what are you saying? This is all on a presupposition, on an assumption. What is the reality? Have you come across with anything? The reason is very well known, not to us. When you say so, the reason is obvious. What has actually played in the mind of the object?
4 persons are there.
At least I can share, I'm bold enough to share in the open podium as well.
He has quoted 37.70 below, and another person he has also given 36.99.
No, mine is
Not that there is any point of discrimination or anything. It's not there.
No discrimination.
AL2, he has given 36.99.
No, I have given
And AL1 has quoted
I have given
32.70. So approximately they are nearer to each other. Both persons. So it's not that they have discriminated somebody and they are not giving it. That's no. That is not the case.
Everybody, sir. That
We have
does not
considered everybody in the same parameter.
If the rejection is based upon absolutely improper consideration. You are augmenting and encouraging
I have no
the
objection if you are giving
offer up to 19.99%.
Yes.
You are offering, you are doing it. Frustrating the way he will come and quote 19.99% less. You will not then invoke. Whoever has quoted less than 20%, then you will say reject. That what does it mean? That means that actually the cost of the work may be less than 35%, but you are encouraging. No, you gain more profit. If you encourage more profit, then behind the curtain also there are certain assumption or a presumption.
No, I have no objection. Let the tender, we take the tender. I have no objection to that. But he has given, she should have given an undertaking that he will suffice and he will make good if there will be any loss.
Sorry?
Because the performance guarantee will not match.
Can
because-
you go beyond the terms and conditions of the NI?
No, that is the whole thing is apprehension. That's
What
what
apprehension?
really apprehending.
What is apprehension? I'm just
Apprehension-
asking you.
That is the only apprehension, and he has indicated in the
We
paragraph.
are imposing a hefty cost to be paid. Now you realize we are imposing. If this kind of things are coming, at one go you are saying it relates to a very emergent situation because to take care of the flood or something of that kind, and then you are doing in such a fashion where again you'll have to go for the another tender, which you have gone. And it is not a single person who has, maybe multiple persons have quoted less.
Yes.
So you rejected, scrap the entire tender. If in this tender also, if they come and quote the price, what will happen? You will give who has quoted 19.99. You quote, you give. And reject every offer less than 20%.
Since the departmental technical committee has recommended, they have no other option but to accept that. The Lordship may take note of the expert committee report and pass necessary orders. Lordship may take note of that and pass necessary orders. We will abide by that.
With imposition of hefty costs. We are doing so you pay the costs of the litigation.
Cost of the litigation.
Yes. Cost of litigation. Unnecessarily, you are dragging something. When you have gone that he has not shown the document that he is having a license of a stone quarry, he has given a consent order issued by the Pollution Control Board to operate the quarry. You have not seen. You have disclosed those documents. And you say that he has not given any document that he is owning that he is having a license of quarry. That shows that you have proceeded with a closed mind. I mean, license of quarry.
It is a frequency.
Absolutely, with a closed mind. The copy of the affidavit?
I am for my senior Mr. Ikin.
You don't know any of this.
I'm a associate of Mr. Ikin. I'm here to serve the. Mr. Nanda.
Yes.
Mr. Nanda.
Yes.
You have been served with this affidavit today.
No,
No,
I was
I
asked
am
for
not
a copy.
served.
Or you are not served.
Just now I filed
I was
it.
asked for a copy in the morning to my learned friend, my dear friend, but he didn't give. So,
No, it was not ready. It was not ready.
anyway, my
Just-
lord, your lordship know the entire fact of the case, and it may not be necessary now at this moment.
What is the date of the last date of submission in the next tender?
29 is the last date, my lord.
No,
for submission.
30th is the opening of the financial year.
29th.
29th is the.
Yes, ma'am.
Give a copy.
Yes.
Deal with all the documents. If you want to clarify this, we are permitting you to file rejoinder to it.
Yeah.
Passing an interim order of staying this particular tender process. D'accord. The petitioner has not only challenged
It is your Lordships. Lordships, here I have challenged the show cause notice and the influence order on two grounds, your Lordships. One, the procedure
Show cause notice to the impugned order means.
and the impugned order, your Lordships. I'm so sorry. On two grounds, your Lordships. First, the show cause notice is a single consolidated show cause notice covering multiple financial years. Two, the assessment order is an incomplete and truncated assessment order in as much as only first page of the assessment order was uploaded in the GST portal. May I, sir, show you at, may I have your Lordships at page 94 for a moment. Annexure 3. This is the assessment order that they have uploaded.
Yes.
Lordships comprises only of one page, your Lordships. It's a violation of section 75 subclause 6.
Not the second page.
No other page, your Lordships.
Regarding the computation, details of the demand.
These are the summary orders in DRC 07.
Correct, but there is.
Though there is no other page, your Lordships. There's only one page which has been uploaded in the GST portal.
Correct, that is what I'm saying. So all the 14 pages must have been uploaded.
No, your Lordships.
14 pages are not uploaded.
No.
Only
No,
one
your
page, cover page.
No. Only the first page has been uploaded in the GST portal.
That is the page at 94 only.
Yes, your
So
Lordships.
it's not even 95.
Nothing, your Lordships. 95 is uploaded as a summary order. Those are issued under
No,
form.
I'm just trying to understand. Sir. 95 was uploaded.
Yes, your Lordships.
96 was uploaded.
Yes, your Lordships.
97, 98.
Yes, your Lordships.
So you say not the first page, yes, but the elaborate order, detailed order has not been uploaded.
Yes,
This
sir.
is, say that straight away.
I'm so sorry.
First page is uploaded and the other page. So I was just thinking what has
Other
happened.
pages are, these pages, 95 onwards, they are not forming part of this 14 pages. Is not.
That's why I asked him. Yes. What
aspect I have to take instructions.
instruction? Where you have made out a case of such nature here.
Chips section.
I am talking about your pleading, sir.
I'm so sorry.
Sure. I got it, page 15.
Page 15. Research.
How this is done? They have categorically in paragraph 13 said so.
Take instruction on that.
What about other notices which are in 2026?
Lordships, those have all been uploaded in the GST portal. Subsequent.
That is for a different period.
For that period, rectification order.
Rectification order has been initiated by the department
And already passed.
and already passed. And that order is also
So moto,
so motor that order is also speaking.
without hearing.
No, they have, we have been heard.
He appears.
Yes, appear.
We have been heard. We have been heard, but
There you
passed.
just point out that original orders were never uploaded,
No, your Lordships, that's not there. I'll be fair.
but you participated in the rectification.
Yes, sir.
On that point, it is available.
Has it
That is there.
been rectified?
40 pages.
Lordships only.
Has it been rectified? The original order is rectified to any partially or fully or what?
Yes, your Lordships. Now they have come out with a speaking order of 28 pages.
True, and that is uploaded. So they really modified or whatever substituted the fresh order with the original order. So that is no longer in existence.
Lordships.
Then in that event, what? Then
Then it is appealable.
Lordships,
And time is
161, your Lordships, it's a
I understand that if the order which you want to challenge extincts or merges with the subsequent order, then what remain and subsequent order is known to you. That is the appellable order or real order which really affects your right.
Your Lordships, they cannot be passing a reason speaking order under the pretext of the rectification order. Lordships may just see.
But they have done so.
Yes, your lordship.
So
Lordships may just see they have now come out with a reasoned order of 28 pages, your lordships, instead of 14 pages. So it was no rectification apparent on the face of it. What they have done is,
according to you, that if the parent order, let us assume, contains 4 pages and a review application is decided with 20 pages, that is not permissible.
No,
You should restrict it either to 4 page or less than 4 page.
I'm so sorry, your lordship.
So it's a how they deal with it, how it matters, 14 page or a 28 page.
Your lordships is all
Is the content is which matters.
Lordships. It all emanates from a single consolidated show cause notice, your lordships. Lordships have been staying it all.
Very elaborately, entire order is
Absolutely.
Lordships.
very elaborately, entire order is
It's
reflected.
Uploaded in GSTR 08.
Order. So after all, I think actually the original order.
Similar as
Item 12.
Here, implement the annex of 5, page 67. Implement the annex of 5, page 0. In the instant case, the case was dismissed from the grounds that Mr. Leonard here appeared on behalf of the SSC through virtual mode, was not in uniform and prescribed in the SOP for appearing in the virtual mode.
This is the
In similar set of facts, my lord.
no, this is the ITAT order. Then the appeal lies.
My lord, this is a similar set of facts.
The appeal lies or what?
Appeal, because it's not a speaking order. Para 7 of the para 7 of this judgment, the lordship might kindly go through where this the Honorable Apex Court has said delivered para 3 and para 7. Page 5, my lord.
Where is the judgment of the apex court?
Page 5
Page 5.
of this page para 7, it has been entered in page 4.
So you want to rely on a quoted portion, not the original judgment.
The original judgment is of this Honorable High Court, my lord. I want to rely upon para 4 and para 7 of this judgment, my lord. Para 7, last paragraph, the High Court exercised purely, para 5, last paragraph. The High Court exercised purely advisory jurisdiction and has no appellate or revisional power. The advisory jurisdiction can be exercised on a proper reference being made, and that
You are referring what? You just tell me.
my lord, in a similar set of facts.
I am asking you, sir, you are referring which portion of this order? This is the
Page 5, last paragraph.
page 5.
Last 5 line. The High Court exercised
the position to put on. The position becomes quite simple.
may I place para
Page 5 last, the position becomes
Do what?
simple when it is
The
quoted.
position.
para 4, page 3.
Just a moment.
The position becomes quite simple when it is pointed that the SSC of the CIT, if agreed by the order of the appellate tribunal, can have resort only to the provisions of section 60. So far as the question of facts are concerned, the decision of the tribunal is final and reference can be sought through the High Court only on question of law. The High Court exercised purely advisory jurisdiction and has no adequate and revisional powers. The advisory jurisdiction can be exercised on a proper reference being made and cannot be done unless the tribunal itself has passed proper order under section 33(4). It follows from all this that the appellate tribunal is bound to give a proper decision on question of fact as well as law, which can only be done if the appeal is disposed of on merits and dismissed owing to in absence of the appellant. The position of law was affirmed by the appellate court.
I think this
And para
position
four-
is prior to amendment or
This
after
is,
amendment.
and para 4 is the section 254(1) has been quoted. Learned counsel for the petition submitted even if the
It does not make a distinction between an order passed without considering the merit or order pass on merit.
But substantial question of law.
No, this is what is the difference. The substantial question of law means whatever the law, the substantial question of law may also arise whether the tribunal was legally competent to dismiss the appeal in absence of the appellant. That's the substantial question of law.
In this,
How can a writ jurisdiction assumes
my lord,
and then decide when there is a express provision relating to an appeal before the High Court itself? It is not before any other authority.
present decision, my lord, it was restored back to the tribunal for.
I am more on a fundamental principles that whether the court should exercise the 226 jurisdiction. How can it be when there is a provision for an appeal?
In the instant case, the petitioner was not heard. Only because of the default of the advocate, the matter.
We understand, then why not the appeal? I am just thinking, you are before the High Court in both the cases.
Not only nomenclature, but
Not nomenclature. What are you talking? Limitation also comes. It's not a sheer change of nomenclature. Every order cannot be qualified that the order which is on merit will come under the purview of this. An order which is on a technical ground will not come in.
So senior regulation is very clear. No, 62, no, 61 is no.
When you play this micromanagement, you restore back to the tribunal matter. And because all on merit, because.
Are you?
Yes, I have understood.
Are you,
what is-
yes, are you understanding what is
My-
playing in our mind?
My contact.
So,
Only a prayer, because
what small prayer? That means that we entertain 226. Here we are at the very threshold, whether to maintain or not to maintain.
SSC is the primary agricultural credit corporate society.
Will the law changes by virtue of this status? If the law, the statute is there, section is there, will it change with the status? It will be uniformly applied to anybody.
The appellant petitioner was not hard on merits. That's 250, it's also the section 250.
I understand
I understood
that is what is why not it is a substantial question of law. What you have done? Mr. Monty, what you have done? I mean, you means your authority. I mean that. Not you personally, but your authority. Well,
The appeal is for the violation of SOP.
what SOP?
The AR was not a proper dresser.
It was not
Proper dresser.
improper
Yes.
dress. That is the SOP.
That is mentioned.
Can I have the SOP? I am this is a digression from the issue. Where is the source of the SOP? What is the source of the SOP? Who has framed it under what
Rules.
provision of the law which permits or empowers them to make it?
Rules.
Sure. Tell me, Mr. Maharti, from where this SOP has come?
Well, section
These are all
70A of
It is
IT.
not a section, sir. SOP cannot have section.
No, I think. this-
Section is a legislative, the exercise. Tell me from where they got the source of power.
These are under rules. These are under rules.
ITT rules. ITT rules.
Yes, from the source of power for SOP.
Four. Starting from four.
Item 14. This page become very slow to do.
That excise laws.
Audit was, report was filed with delay. And my audit report was filed with delayed logs. And
Your
the
audit report was
filed with delayed logs.
with delay. Okay.
And there was section 119 petitions filed before the commissioner exemption was rejected because my stand was that during the COVID period, I was unable to file the audit in time. There was a delay. Similar matters, you also had the occasion to quash it.
Delay, condoning the delay.
Condoning the delay. And the logic have also held that this is a procedural matter. I've just made the correction. I'm sorry, because this is the. So far as the COVID part of it is concerned, the lordships have considered it, it's in paragraph 6.2 at page 5.
Yes, why you insist? Delay audit report, accept it, and then whatever you want to do it.
These are 460 days. 460 days.
COVID period, 353 days.
He is entitled to a exemption or the exclusion of the period in terms of that Supreme Court judgment.
So much of it. Page 23 is the order, no, that's it. I made the necessary corrections.
Item 15.
Item 15.
Mr. Correction कर दीजिए. Mr. Mr. Correction कर दीजिए.
No, we have corrected.
Yes, correct. Yes, correct.
Item 15, RC conclusion.
Item number 16.
And not here. And refund application has been rejected. Like refund application has been rejected. And I filed an appeal. Appeal order is now in favor of
In your favor.
in my favor. Now, when again I apply for the refund, now they are rejected by refund appeal because that really have to go for the tribunal. Because
No, the department has gone to the tribunal.
no, they have not gone.
You're not.
Is there any stay of the operation of
My God, that
There is a provision. There is a
God,
provision
that once the state has, the department has gone, automatic stay.
Commission is to withhold the refund. Commission is to withhold the refund.
In every case, without looking to
No.
any criteria is not given.
then 54 million.
Instruction, let me take instruction.
Like appendix.
Please tell me when, what is the date of the impugned audit?
Impugned order will not sustain. That I can't, that I have to concede. Your lordship, that impugned order will not sustain because that ground cannot.
So I just looked at one date and then.
I surrender myself, your lordship, because that cannot sustain. I surrender myself. Only I will take instruction. Yesterday we have filed appeal. since 30th June is the last date. Yesterday we have filed the appeal. So let me take instruction in the meantime. Any appeal has been made on that. I'll consider.
No, without the grounds of appeal. Without the grounds of appeal.
ମତେ ଦେଇନାହାନ୍ତି।
ହଁ ମୁଁ ଜାଣିଛି
ନାଇଁ
ଖାଲି କଭର ପେଜ ଟା ଅପଲୋଡ ହେଇଥିବ
ନାଇଁ ଏବେ ହଉନି
ଏବେ ହଉନି
ଏବେ ଏଣ୍ଟାର ଏଭ୍ରିଥିଂ ହାଜ ଟୁ ବି ଅପଲୋଡ।
ଏଇ ଦେଖିଲେ ପରା କଭର ପେଜ ଟା ଅପଲୋଡ କରିଛନ୍ତି ଓରିଜିନାଲ ଟା ତାପରେ ରେକ୍ଟିଫିକେସନ ରେ 28 पेज लिखिदेले
What violation is DSAT there? DSAT में पूरा टोटल करे थे। DSAT how?
Your Lordship will pass this informed order. Your Lordship, on the next week, Your Lordship, let me take one instruction because admittedly, Your Lordship, there is mistake in the first appeal order, Your Lordship.
Totally, they are flouting the order of the first appeal.
There is no interest will accrue. If you withheld will be there as per section 54(12), if interest will be accrued.
Wrongly, I have reported that 30 lakhs.
Mr. You are addressing this court.
Simply may adjourn to next week. 1 week after.
5411 is the procedure. They are mentioned in the order also. And as per the tribunal, they have to obtain the stay from the tribunal also. They have to file the I.
This has to go.
Your Lordship, because
Number of judgment.
I will look into the provision 54.
On that date, you don't have the.
You don't have, so it has to go. What we are proposing is to remand the matter back to the authority to reconsider the application within a time frame. So let them say whether there is a stay, there is no stay, whatever, what is required to be done, let him do. But on a wrong assumption that you have a right to go for an appeal and then
that cannot be. I shall not. That cannot.
There cannot be a proposition.
Recently, my lord has passed the order in which also there is Kavalaki and Procedural person.
You have given an opportunity to appear.
When
No, he was given an opportunity, the taxpayer. It is recorded.
Your Lordship.
In 5411.
In this order, you were given an opportunity.
Yes, I have filed a reply also.
Yes, your submission is recorded that there is no stay or something, but he has proceeded on the basis since the right to appeal is there for 6 months. When there is no appeal.
Your Lordship, kindly 2 months.
Gone.
Interest will there. Interest is there, Your Lordship. Being withheld.
Get it state.
Not required. 5411, 5412 is there. 5411 is there. If a commissioner can, Your Lordship, when Your Lordship may kindly look into the provision. 1 moment, Your Lordship. 5411 says, Your Lordship, when the commissioner, where an order giving rise to refund is the subject matter of an appeal or further proceeding, or where in the other proceeding under this act is pending, and the commissioner is of the opinion the grant of such refund is likely to adverse affect the revenue of the said appeal or other proceeding on account of malfeasance or fraud committed, he may, after giving the taxable person an opportunity of being heard, withhold the refund till such time as he may determine. Your Lordship, my respectful submission, this order will go. Your Lordship, in the meantime, we have filed the appeal. That junction of appeal, Your Lordship, has been sustained. Now the appeal has been filed. Now this proceeding, commissioner has to call for him, Your Lordship, for appearance. And Your Lordship, if applicable, then commissioner can take action. If not, then he has to issue the report. And 5412 says that even for the withheld period, interest will accrue. And he is eligible to get back the interest along with interest. So there is only for the loss of revenue.
54?
5411. So only yesterday we have filed the appeal since the 30th June is the last day. Yesterday we have filed the appeal. And that proceeding may come, Your Lordship. For that reason, I may pray 2 months' time. This may be remanded, Your Lordship. I am not supporting this order.
Yeah.
54.
Brother, can I dictate the order? 5411. Let us see what you are interpreting. Let us see whether it really conveys that.
So the pop, that space has not come here. I withdraw my words. I withdraw my comment. I am always here of always. May not pass any observations about that stage has not come. It is only mine. What the department will do, you know, let them do it. Your Lordship may remark.
India High Court doesn't guideline para 11 and 12.
Sir, I have read, but that is a half. Something more is to be infused in the section itself. That is all given. What is malfeasance and the fraud?
Your Lordship.
So, what is the importance of these two words appearing in section 5411? Malfeasance and fraud.
Where is your finding?
Your Lordship.
What is automatic refund withholding the refund?
It is a future action and not
Automatically.
Oh, hearing opportunity.
Or only two grounds, malfeasance and fraud.
For that reason, this is what the department will do. Let them do. Let them. They have not done till it because yesterday the appeal has been filed. After filing of
I'm interested in saying that it has got a very restricted applicability.
Now you will proceed for investigation and find out.
No, that is there. That is there.
Already is not there.
I don't want to back.
For the sake of appeal, you have filed.
Your Lordship, let it be remanded. Let it be remanded.
That there was no pending appeal, and therefore it is.
Here they have allowed the refund and wanted to proceed further. They have given the liberty.
Now something more there, it was not there. Must have approved, Mr. Mishra. Yes.
Item 17.
Your Lordship may grant 2 months.
What 2 months?
Yeah, yes.
Or let my brother decide whatever.
Item 17 is the running of liquor shop near to schedule and residential under Gram Panchayat. Okay, despite it receiving objection by them.
The school was established prior to the establishment of the shop or after the establishment of the shop?
Prior to the establishment of mine.
So how they have given, they have allotted?
And now the shop is running, my lord. The liquor shop is running. Even a resolution was passed on 20
So there must be a objection or hearing of the villagers, I believe.
No, they have received complaint as well as objection. On
So have they not conducted the hearing before allotment of the shop?
On
So-
22/12/2025, a resolution has passed that all the country liquors of near to the village of Vadodara, in village of Vadodara to be closed. That is in Annexure 3, my lord.
No, there is a provision in the excise rules regarding the public hearing.
Rule
230, my lord.
Correct. Was it not done?
Here, my lord, I have just the inquiry report, my lord, I don't have the instructions. The inquiry report says that the shop is running since last 20 years, my lord.
No, my lord, not 20 years, my lord. That is 2000, February 2000, in 2024, we submitted a complaint. I mean, the Sarpanch submitted a complaint as well as objection. They have received the objection, but despite that it was operated
20 years before or 20 years after?
20 years. I have to tell you, I think what my instruction is coming, that is not for 20 years.
20, then how many years?
Now at the time.
How many years it is running?
5 years. But my instruction is coming, that is 5 years. But at the time of renewal of license, when they have resolution was passed to receive objection, the objection has been submitted. But despite that, it is running.
There must be some procedures which is to.
Section 41(1) proviso says that provided no objection shall ordinarily be entertained for shops continuing in an area for more than 3 years.
My lord, paragraph 2 of I have written that it was earlier it was running in a lonely area, but for last 2 years it is running in near to the hospital, and near to Sishu Mandir is also there.
File your affidavit. 2 weeks, rejoinder 1 week, 4 weeks.
From 18.
May I please allow, sir? But here, my lord, in honoring your
On shop, off shop.
CLs against the demand, my lord, honoring your lordship's order at page 33, where my lord was pleased to direct the collector Cutter to reach at a logical end, taking into lordship's judgment. I was issued with so-called notice thereafter. Lordship kindly come to page 48, annexure 6. The operating portion is annexed at page 50.
So we have said that they have already initiated.
Proceeding. I submitted my explanations. Thereafter, Lordship may come to operating portion, that is page 50. That is of annexure 6, page 48, but the operating portion, my lord, page 50. Therefore, it is hereby ordered that the Noya Bazar sale shop shall be closed and sealed forthwith at its existing locations, my lord. But since then, this is 12/12/2025. Though my license was valid till 31st March 2026, it was immediately sealed and closed. Then, my lord, they proceeded with the shifting. Very next annexure, page 51. Because prior to lordship's direction, I had submitted my shifting application to another place, man. They proceeded with the shifting application. Let's see. Then, my lord, annexure 9, page 56. My shifting application was rejected in view of pending excise duty non-renewal of the said license for the extended period. My lord, they have closed. I have stopped operating the shop. How I will pay? Because till 31st March, I have paid everything. Thereafter, I have not lifted because of the closure of the shop. I have stopped. Now, Lord, after rejection of my shifting application, by the election 11, my lord, now they have raised a demand. Document page 73. Last portion 75, last 2 paragraph. As the license did not turn off renewal, the extension of license, my lord. How I will turn off, my lord? My shifting application has been rejected. My shop is closed. I am stopped to lifting the MGQ. Now they raised and asked me to pay 49,86,000 during that closure period. That closure was involuntary as per your lordship's research.
What period?
That period, because till 31st, I have paid all these statutory dues, my lord.
Yes.
Since April, they have extended till 30 June. Now they have raised, you have not renewed, you have not lifted.
first maintainability of the writ petition. That's rules, section 6 read with rules.
This is apparent, where you have your own order says that you close, you cannot operate.
He was initially, when the license was granted, he was functioning in an unauthorized place. Then that information.
Did you issued any notice on them? Did you cancel the license or any kind of a thing? Nothing.
Annex 7, impugned order at Annex page 73. If I may refer to the impugned order, my lord, the entire history and how there was a petition which was filed before the Honorable Court by another third party saying the same thing. Thereafter, an inquiry was called for. In between, he had filed an application for shift shifting. He could not function at that place only because of this. He was functioning at an unauthorized place. That was
show us the license that it was authorized for this premises, and he is operating from the another premises.
Annex 11, my lord, if I may read the impugned order, my lord.
Yes.
After field inquiry, the inspector of excise rural range reported that the shop was functioning in an unauthorized, unapproved site over plot number so and so. On detection of such irregularity, Shoker's notice of dated 17/11/2025 was issued to the EP holder, calling upon him to explain as to why action shall not be taken for operating the shop in an unapproved location in violation of the license condition. The EP holder submitted his Shoker's reply on such and such date. In course of the hearing, the matter of the matter in the court of the collector Cuttack on 27/11/2025, the learned advocate appeared on behalf of EPF, stated that the EPF has been arrayed as opposite party number 5 in writ petition, the other writ petition, and the matter was pending before the Honorable High Court for adjudication. So the result of the hearing was kept withheld. Subsequently, pursuant to the disposal of the writ petition passed by the Honorable High Court, the CL shop was closed and sealed forthwith at the existing location so and so, at the loss and risk of the effect on a proper stock taking by letter dated so and so, so and so. In the meantime, on 18/11/2025, the EPF holder applied for shifting of the said shop to one new shop. After maintaining all the legal formalities at the district level, the proposal was recommended to the Excise Commissioner, requesting to consider the proposal and move the same to the Government and Excise Department for necessary approval of the shifting by relaxing the violation under Rule 26(b)(c) of the Odisha Excise Rule. In the meanwhile, the financial year 2025-26 was over, and the EPF accrued shortfall of so-and-so amount by the end of March 2026. After release of excise policy 2026, followed by subsequent letter of so-and-so, all existing licenses were intimated by letter dated so-and-so to take immediate steps for deposit of the required excise dues along with the renewal fees for extension. He did not do so, my lord. So, for his own wrongs, he was not able to lift, my lord. And as per Rule 34, there is a mandatory requirement of lifting of the NGQ, my lord. And if there is any shortfall, pursuant to that, there's...
Can you show me the license granted to him at what was the plot number?
Yes, ma'am. It's number 31.
Which piece he was reading?
Page number 29. my lord.
Next to 2.
Annexure 2.
29.
Yes.
There is no reflection of plot, Malad, only the address. The one number has been reflected. And the address of the license, that's all.
In your application, you should have. In your application, you should have disclosed.
No,
the plot.
Another licensee, he came before Lordship. In course of hearing, the Lordship found that the proceeding has already been initiated. So Lordship had directed to the collector.
You have not given a plot number.
Well, that order.
Whether this khata number such and such is not coming under this Naya Bazar area in ward number 42.
It's just adjacent plot.
Kindly come to page 35.
It was just adjacent.
This is licensee's letter. Accordingly, I have been selected.
Plot number 103, 803.
No, one for,
No. The shop was made functional over plot number 803. Continues.
with respect to this
1 month.
140.
Says for that he has said kindly, but he wanted to go to 1407, but actually he was found functioning not in plot number 803 but 809. 809. So that is what it says that.
Lordship, may kindly come to Annexure 4 series where I have reflected the plot. The existing plot, there also I have submitted the proposed place for shifting. Page 35.
Sir, what plot number you gave?
That is, my lord,
803.
803.
And you were found operating from 809.
No, just that is the understanding.
Whatever be.
Yes, my lord.
Can it be?
On that ground, my lord, your lordship had selected collector to proceed.
No, sir.
Proceeded and this.
So if they have, you could have continued with the 803.
Page number 49, his own admission, he says that the approved site is adjacent plot and ward, my lord.
Yes, my lord. That date of hearing, my lord.
We can't.
Now, during closure period, they have demanded.
No, this is not a closure. Closure of the shop at 809, not 803.
Yes.
803 was unhindered.
My lord.
That's all.
Then, my lord, I shift my shifting applications. This is just 17.
Sir, you can operate from 803.
I cannot operate.
That's up to you.
My character, my shifting applications, they reject immediately. They could have.
What was your application?
My lord.
What was your application?
Annex of 4 series?
803?
No. Lordship, see, the last.
809?
That Annex of 4 series, page 35.
Read.
Yes, sir.
35 is shifting, sir.
Shifting, that is, my lord, plot number 1407 oblique.
That is, you wanted to go there. From where?
From 803.
And you were not operating in 803, you were operating in 809. Illegally.
That's why your lordship took.
That's why we can't. The closure was as 809.
Yes.
But there was no difficulty in 803. They have not closed 803.
No, 803, that is the.
They have not suspended the license. Kindly visual. I have seen that you cannot operate from plot number 809.
803, my lord.
809, not 803.
Because previously, last 10 years, the shop is continuing there over there.
I do not know without, if you can shift yourself.
During validity of my license, I have applied for shifting. That has been
rejected. The shifting means the closure. I'm asking you, sir. Shifting means a closure. Closure. Oh, let me understand the height. That means I may continue at the existing site, but I wanted to shift it. If you permit me, then I will shift myself. That does not prevent you from continuing at 803.
Lordship may see the grounds they have taken, my lord. Only the Lordship may see that impugned order.
The ground is that you have not lifted the MGQ. Now you lift the MGQ.
That is the only ground they have taken.
Another interest.
Non-renewal of land.
It is addressed to the collector by the party.
No. No. Good. Two weeks, 3 weeks, 4 weeks. Nothing. What is this? His department appeal.
Department of
Item 42.
IT appeal, OT appeals. You have filed. Who has filed?
Mr. C.H. Satyajit Mishra.
Satyajit Mishra is there, but you filed at that time.
Right now, I'm not in the panel. It is Mr. S.K. Rai Chaudhary is appearing in this.
Where is he?
He has led the cause.
He has asked for a withdrawal. Has he filed a?
Yeah, IA has been filed.
IA is there.
IA
is there.
Hello.
He was just sitting.
He was there, my lord. Just
You,
now.
Hello.
you intimate him.
I will intimate. I will.
Next.
Item 43.
It's a Prosenjit Mahapatra.
Item 43 for withdrawal.
Yes. Next.
Item 44.
Mr. Sarat Kumar Gajendra, L. Pradhan, DP Das, VP Das.
IA is filed.
IA for withdrawal.
State. Yes. You have any objection?
45.
Item 45.
Pradhananda Mahapatra. IA filed. It has not yet been. You have any objection?
Right.